In today's presentation, I will be discussing and analyzing the following statement. While orders of an emergency arbitrator are not enforceable under the New York Convention 1958, emergency arbitration remains a highly effective path to emergency relief. So what exactly is an emergency arbitration? It is one in which an arbitrator is appointed to deal with requests for urgent interim relief, such as interim injunction before the main tribunal is constituted. Relief is granted in the form of an order, which may be later revisited by the arbitral tribunal once constituted. Traditionally, parties to an arbitration couldn't obtain interim measures before the constitution of the tribunal. If they wanted interim relief, the only option was to go to a national court. As the constitution of an arbitral tribunal could take months, there was a risk that one party would suffer irreparable damage in the meantime. Emergency arbitration procedures have developed in order to mitigate this risk, and most major arbitral rules have now introduced emergency arbitrator provisions. When is it available and what are its key features? Using the ICC rules as an example, under those rules, a party in need of emergency interim relief prior to the constitution of the tribunal can apply for that relief at or after the time they file their notice of arbitration. The applicant must notify the Secretariat and all other parties of the nature of the relief sought, the reasons why such relief is required on an emergency basis, and why they are entitled to such relief. Relief can only be sought against a party to the arbitration agreement, and the emergency arbitration provisions will not apply if the arbitration agreement predates the relevant changes to the ICC rules, or if the parties have opted out of the emergency arbitration's provisions. An emergency arbitrator will be appointed and will hear and decide the matter on the basis of written and/or oral submissions. Timelines may vary, but typically an emergency arbitration takes around 8 to 10 days from application to award. An emergency arbitrator can usually order any interim relief necessary, including interim injunctions and freezing orders. What are the limitations? Despite the increasing popularity and prominence of emergency arbitrator appointments, parties should be aware of the limitations, particularly when compared with the court order interim measures that can be granted in support of an arbitration. In particular, as identified in my research question, there are doubts as to whether rulings issued by an emergency arbitrator are enforceable before a court. Many legal commentators consider that emergency arbitrator awards are not final and binding for the purposes of the New York Convention, and therefore are not enforceable under that regime. Not all commentators agree with this position. Some argue that interim measures are final and binding in relation to the matter at stake, namely in relation to interim and conservatory measures, and therefore should be enforceable under the New York Convention. Some jurisdictions such as Hong Kong and Singapore have amended their local legislation to make emergency arbitration award enforceable. Another notable jurisdiction is the United States, where a number of judicial decisions have recognized and enforced interim relief granted in an arbitration, including relief ordered by an emergency arbitrator. A good example of this is Yahoo and Microsoft companies. However, enforceability will continue to be a problem in many countries. In China, for example, only courts may grant interim relief. An emergency arbitrator's award will not be enforceable in China. In conclusion, the effectiveness of the emergency arbitrator process doesn't depend solely on the legal enforceability of such orders, but rather on a number of factors which would motivate voluntary compliance. In those circumstances, it is perfectly useful and can indeed provide a lifeline to a claimant at the early stages of an arbitration.